following program was provided by an independent producer solely responsible for its content. The opinions expressed do not necessarily represent the views of this station, its staff, board of directors, or underwriters.
Every day, citizens around the country are faced with new dilemmas. Dilemmas that affect them profoundly. Whether it's injustice, discrimination, falling through the cracks, scandals and cronyism, balances of power, ethics, religious freedoms, state versus citizens, and unfunded mandates, and the list goes on and on and on. Welcome to Speak Up. It's directed at those who have fallen through the cracks, and it gives them a voice. It's your turn to speak up, to stand up and fight back.
Welcome to Speak Up. I'm Kevin Avard, your host, and we're doing a series on parental alienation. And today I have a couple of on my show that Ron and Sherry Palmer, and they wrote a book. The book is called Not in the Child's Best Interest. And I think this information is going to be very valuable. They hail from Dallas, Texas, or around that area. I want to welcome you two to our show.
Thank you.
Thank you.
The title speaks volumes to me, Not in the Child's Best Interest. Nowadays, we're hearing this term called parental alienation. And I thought it was just a local thing here in New Hampshire. We had a recent interview with Linda Gottlieb, and that information, apparently this is something that happens from Australia to Alaska, this whole parental alienation syndrome. And you wrote a book based on what is really in the child's best interest. And I wanted you to talk a little bit about your book, if you don't mind. You both wrote this together?
We did.
You know, one of the things, when people are going through a divorce, they feel as though they've been a good parent, they've never committed a crime, they've never done anything wrong, and all of a sudden, one of the parents, it could be him or her, find themselves totally on the outs with their children, and it seems as though the courts facilitated this. Why are the courts in charge of determining who gets the child?
Well, they really, Constitution, they're not, but it's a 300-year history of the court stepping in and taking over in cases of divorce. And it has a lot to do with the way our society and our laws have changed and grown, particularly over the last 50 to 75 years. Right? If you remember back 50, 75 years ago, women couldn't work very easily. They couldn't support themselves. The laws were very different. And so our family law system was very different as a result. But since we've had numerous rulings by the Supreme Court regarding equal rights for males and females, those dynamics have changed. Our society has changed, and all of the underlying assumptions that went along with how the courts did this have changed. And there are also a number of other Supreme Court rulings having to do with parental rights in general, applied to individuals and related to couples. And all of that has kind of changed the nature of the laws and the framework under which we work generally. But the family law system simply hasn't caught up. We have these deep fundamental biases about divorce that allow us to put on blinders and treat divorcing parents as if they're second-class citizens and completely ignore the Constitution and what the Supreme Court has said about parental rights.
I am reading the book, by the way, and I'm loving the book. One of the things that struck me out early on is that the courts really go out of their way to defend parents' rights when they're married.
Absolutely.
But what happens, what magical thing happens when if a couple divorces? Where does the child in the marriage agreement become property of one parent versus the other parent? Am I approaching that right?
Well, historically, parental rights were tied to marriage. In fact, uh, a child wasn't legitimate unless they were born to a married couple. We had what were called bastardy laws that said children that weren't born in marriage were second-class citizens. They couldn't inherit from their fathers. They had all of these unequal positions in the world. Now, we've overturned all of that, and we said that is no longer the case. That can no longer work. Rights are individual, rights attached to the individuals, and the rights of parents do not attach to the marriage itself. They are not granted as part of the marriage. They are not dependent on the marriage. The rights of individuals, whether married or single, must be the same. And that's what the United States Supreme Court has said. And they've said this over and over again. Even in the most recent hearings with the Supreme Court, where that had to do with the adoption of an Indian baby, the Supreme Court was very specific in their questioning of the attorneys in what they termed a family, whether a single individual was considered a family with their child, right? So they are very particular about this idea that families are not the traditional nuclear family with two parents, man and wife, male and female, and their children. Families come in all shapes and sizes, and they are individual parents with their children, even if there are two living parents. Each one constitutes a family with their child.
And if I may interject, part of what we see happening is it happens in a lot of areas in courts, and that is when our communities change and our structures in our lives change, the courts are much slower to adapt to that. Some of that's for good reason. You don't want your legal system changing too quickly. But the other part is because sometimes they have difficulty integrating the new stuff. And so like in our cases with families, we went through the shift like my husband just explained. And then we came upon where fathers always got custody because they were the breadwinners. And remember, like he said, the women weren't allowed to work. Then once the women were able to start working a little more, but still couldn't make it on their own, they came in and said, hey, wait a minute. We have rights to our kids too. And as a matter of fact, we took care of them most of the time. We're the caretakers. So that's where it came in. Now the men were losing custody and having to support the woman. So as you go along this timeline, families have shifted further again. Now there are women that are the breadwinners. So some of the roles have swapped. But now both parties can work. They're able to have equal access to pretty much everything. Right. Except VAWA, which we won't get into. But
so part of
so let me kind of finish this thought. So basically what's happened now is we haven't let go of that male-female battle now, where it shouldn't be that way anymore because we got the constitutional protections under the 14th Amendment. Now we're still stuck in, we think we have to fight over which parent's better, man or woman, mother or father. So we're stuck there. And what our book tries to do now is help people break past that barrier, because the way we think and the ideas we put around divorce are super powerful, as you see. And attorneys are going in and giving people what they say they want. And so they plead that, which takes us to now the judges in the trial courts have to act, well, not all of them do, but pretty much you frame the case in front of your judge, and so does the other side. So if each party is asking that judge to take rights away from the other person and not protect each other's rights, now you've just handed the judge the power to determine who gets what rights.
And part of that is historical. It used to be that children were property and that only men could own the property. So 200 years ago, people used to basically lease out their children into indentured servitude, and the male of the family, the male of the household was allowed to keep all of the earnings of those children. This was a very common practice from colonial times up until about 100 years ago. So most of our understanding and our legal basis for child custody is based on the fact that children were property and that only one person can own the property, basically. And so who gets the property? Where our legal basis for all of this has shifted over the last 100 or so years, 150 years, is that we've come to understand parental rights and children's rights under the term liberty, under the 14th Amendment, and the idea that there are liberties that can't be taken away from us by another individual. They don't belong to another individual. Now, the state can punish us by taking them away, such as our freedom to move around. They can put us in jail. They can take money from us and fines and penalties and those kind of things. But those liberties belong to you, and you can't give them to anybody else. Everybody else has them.
What gives the authority to take a child away? What are the three, you mentioned in your book that there are only three reasons a judge can take a child away.
Right.
You want to talk a little bit about that?
So the Supreme Court said that a state court cannot come in and simply take over from a fit parent and determine that child's best interest in the face of a fit parent. It is presumed that fit parents make the decisions that are in the best interest of their children. So until you can prove that that parent is unfit, the judge can't override those determinations.
Is that why there's, let me interrupt, is that why there's a rash of false allegations against the other parent? Restraining orders, Your Honor, he's a risk, she's a risk, she does drugs, he's violent, he does this, then they automatically get a restraining order, and that puts the person who's being restrained on the defensive, and now I have to prove myself innocent.
That's part of it, Kevin. The other part of it is that nobody holds the trial courts to a level of due process. And so they come in and instead of actually making them prove that that person is actually unfit, they tend to try to redefine it and just say, you're worse than the other parent. That doesn't make them unfit. And so they come in and just completely forget about the actual strict scrutiny level that they're supposed to use with the liberty, because remember, as Ron said, they haven't gotten used to the idea of what it means that to be equally with your child and have equal time and rights is a liberty, not a property anymore. And so they come in and they make these allegations to inflame the emotional part of the court into thinking they need to protect the child. And now you've got the situation where the judge is like, oh my gosh, what they forget is what exactly are they protecting the child from? And then they don't require them to actually hold that type of hearing, which would be a quasi-criminal or criminal type of hearing on child abuse, child endangerment, and they don't get to redefine these things. But in family court, everyone gets worried and scared because the judge has enjoyed so much absolute power and absolute discretion that they all feel that they need to please the judge and do what the attorneys say that they need to take from the other parent just to hold on to their part of their rights. So these parents that are making these allegations, most of the time, from my experience with people that I talk to, are doing it because they feel that if they don't prove the other parent bad, they're going to lose their part with their child.
Well, how does one insert their constitutional rights? Well, wait a minute. I have no criminal background, and yet you accuse me of something, and now I have to have supervised visits with my child? So who the heck are you? You know, wait a minute.
The way to do that is in the pleadings. When you file your initial, now we're not lawyers, right? So we're not telling you the legal details of how to do this. We're talking about the logical process of the law and where all these things take place. You still need an attorney to do this by the letter of the law within your state. But according to the Constitution, and the way this all works generally, is that you file pleadings with the court and you show your cause for why you want the court to do certain things. Now, when you file your pleadings and you say the court has wide discretion to determine best interest of the child, you've just bought into their system, you've been suckered into their system, and you're telling the court, judge, make a decision. We want you to make a decision because we're getting divorced. The way to change that is say, we're coming to this court for a divorce between two adults. We want to dissolve our marriage. We do not wish to divorce our children. We are not giving up any of our constitutional rights to our children. We do not believe this court has jurisdiction to determine the child's best interest in the face of two fit parents.
And
All the court can do is divide those rights equally, or really, even more technically than that, is determine when each parent can exercise those rights. And each parent is equal in this, so that has to be 50-50. We're equal in divorce, we're equal in marriage, and there's always conflict there between those rights, but the mechanism of the marriage gives us an informal way to resolve those conflicts of rights.
How are the children's rights? Where does the Constitution protect the children's rights in all of these proceedings?
So children have First Amendment rights, they have 14th Amendment rights. Those First Amendment rights are to be educated by their parents, to receive the religious, the moral, and the civic values of their parents, and to receive those equally from each parent. Now that education comes through example on a daily basis. You don't sit your child down one day and say, here are all my values, we're done. That goes through daily interaction and important things like when the child comes to ask you for money to go to the movies with their friends. Those are all points in time where you get to instill your values on those children. That's First Amendment and 14th Amendment protected.
so the way you protect the children with these arguments is you're saying the children do not get burdened with having to decide what parent they don't get to spend an equal amount of time with. The children's rights are actually that they are protected to be with both parents, regardless of whether the child even says that they want to be with both parents, because they may say things like, I want to drive a car, but the law says you can't do it until a certain age. So putting the child in the position where they're having to make these decisions that even the judges don't like to make is where this protects the children, because the children have the right to not be involved in these parental disputes, right?
And children's rights are different from adult rights. Children have all the full rights of adults, but they don't have the capacity to exercise those rights. So they're required to be in somebody's custody until they're reach an age of maturity where they are able to exercise their rights on their own. So essentially, whoever has custody of that child holds that child's rights in, what's the right word? They hold those rights in trust for those children.
Okay.
Right? And they make the decisions that are in those children's best interest. And parents have that right, according to the Supreme Court, to make those decisions for those parents, for their children.
Yeah, and actually, when you put
We have one case that we've been working with at the Center for Redress, the Vandenberg case, where Dr. Vandenberg wanted to pray with his child, but the mother didn't want that. And eventually, I guess the child didn't want that, and so the mother helped the child make that decision. Long story short, 3 years, Mr. Vandenberg has not even been able to pray. He's only had supervised visits. A sealed envelope went before the judge. The judge said, Mr. Vandenberg, your daughter doesn't want to be with you now. Now, keep in mind, the mother is in the psychological field. And I listened to the audio court hearing, and the judge says, I have a sealed envelope. And in the sealed envelope, your daughter wrote to me saying, Your Honor, I don't want to be with my dad. But Mr. Vandenberg was not allowed to see that document.
Yeah, that's
a violation of due process.
Oh, and then we also have the Johnson case here in New Hampshire. And they actually filed petitions with the House, New Hampshire House of Redress of Grievances while we still had it. Now it's gone. But again, here's another father who had more than 50% rights, all the way diminished to nothing, no visitations, and all based upon what was put in a sealed envelope. I'm sorry, Mr. Johnson, you can't see your child because of what's in the sealed envelope. Where did these fathers go wrong in defending their rights and their child's right?
Here's where it goes wrong. The very beginning. I would venture to guess that the pleadings said, we want the court to decide what's in the child's best interest. So from the very beginning, he was giving that judge the power, or the judge has the power, sorry, the authority to make those decisions when he and his former spouse didn't agree. And that's a huge fallacy. First of all, parents do not have to agree with each other. When you separate your individual, your rights go with you. You're protecting your child when you protect your rights, because you, as Ron said, you are the one that you're entrusted with to raise that child your half of your time. Now think of it this way. You could have two married parents. Not all married parents live together. I hear about these couples in New York, they live on opposite sides of town. They have a child, that child goes and stays with each one half the time. They're in the marriage. The government never ever steps in when the child says, I hate you, Dad, or I hate you, Mom, I don't want to go over to your house this time. The government never steps in. So when a parent goes and addresses the government and asks them to step in a divorce, they're actually remiss in thinking that they have the jurisdiction to do so. And if a parent learns that from the very beginning, they're able to challenge that and shut that down much more quickly. Now, yes, judges can abuse their power, but that will get less and less and very limited as parents stand up to that power.
And your book, you help people walk through this. You talk about how to start, not that you're encouraging divorce, but you're basically helping them, if it is at its end, how to start the process properly, how to educate your lawyer on this particular issue, so that you don't give up your rights in the process.
Now, the foundation of this book goes well beyond divorce. The foundation of this book is parents' rights and child's rights. We frame this book in context of divorce because that's our experience and that's what we suffered all of this pain from. This is the process that hurt our children, and that's the process we want to fix. But there are other processes out there where states try to hurt parents and deprive parents of their rights. And all of the cases in this book can be applied to that as well. So it's not exclusively about divorce, but the arguments are framed in terms of divorce.
Yeah, the book is a basic foundation, because what we're finding is happening is parents, attorneys, judges, they don't even have that basic understanding of what their rights are, and that's causing the problem. They don't, if you don't have the information in your head, you can't use it. So
can we ask you to come on at another time to talk about some more topics on your book?
Absolutely.
I would like to ask, though, if there's one message that you want to leave with parents today. They got the feeling that they may be going through a divorce, and they have 2 or 3 children, 1 child. What final thought do you want to leave with them right now?
To understand those rights so that they can defend them properly. They need to find out quickly what those rights are, and they need to frame this process properly for the courts so that they don't lose their rights. Or if they do at the trial court level, that they have a foundation to appeal and get those rights protected.
Not in the Child's Best Interest by Ron B. Palmer and Cheryl L. Palmer. How do they get in touch with you?
Sherry.
Sherry. I read it too. Of course, I didn't have my
Sherry's
glasses.
her sister,
Sherry L.
otherwise
Palmer.
it wouldn't be such a big deal.
How do they get? Is your book on Amazon?
Yeah.
It is.
And you have a website?
fixfamilycourts.com.
fixfamilycourts.com. Well, until next week, thank you very much for watching Speak Up. We hope that Ron and Sherry have been a help to you. We want to encourage you to get this book and to learn more about your constitutional rights, your children's constitutional rights, and let's solve this problem. Parental alienation syndrome is not just affecting New Hampshire, it's affecting the globe. So we want to bring more awareness to this, and until next week, thanks for watching Speak Up. Thank you for watching this episode of Speak Up. We also want to thank our sponsor, Center for Redress of Grievances, LLC. You can reach them at www.centerforredress.com. If you want more information about Speak Up or want to be a guest, you have something to say, contact us at speakupnh@gmail.com. And thanks for watching. Until next week.
Every day, citizens around the country are faced with new dilemmas. Dilemmas that affect them profoundly. Whether it's injustice, discrimination, falling through the cracks, scandals and cronyism, balances of power, ethics, religious freedoms, state versus citizens, and unfunded mandates, and the list goes on and on and on. Welcome to Speak Up. It's directed at those who have fallen through the cracks, and it gives them a voice. It's your turn to speak up, to stand up and fight back.
The preceding program was provided by an independent producer solely responsible for its content. The opinions expressed do not necessarily represent the views of this station, its staff, board of directors, or underwriters.